Our next case on the calendar is Marsh versus Value.
May it please the Court, my name is John Stemberger, and I'm here this morning with my co-counsel Shannon Akins. Together we represent the plaintiff appellate in this case, Jill Marsh. Your Honors, the current legal authority as set forth by this Court in the well-reasoned Fry cases of the last decade, we believe should turn on the outcome of this case in favor of the plaintiff. Specifically, we would cite this Court to the two most recent Fry decisions as being controlling and dispositive, that is U.S. Sugar versus Henson and the Castillo versus DuPont case. And Your Honors, we would primarily make two arguments this morning. The first argument is that Fry does not apply in this case because the experts rendered pure opinion testimony based upon their training, education, and experience.
Now let's get to the issue on that is, I think the defendant doesn't contest that whether your client has fibromyalgia is pure opinion testimony that is not subject to Fry. The question is whether the issue of whether trauma can ever cause fibromyalgia is one of the principles on which that pure opinion testimony is based, and that is subject to Fry, and that there is no consensus in the medical community. It's not clearly established that that's the case, and therefore that's why your expert testimony is not admissible. So why under our cases and all the other cases, why isn't it the case that that principle that trauma can cause fibromyalgia is not subject to Fry?
Well, first of all, Your Honor, again, we would submit this as pure opinion testimony. Fry is invoked when there's new and novel scientific methodologies, tests, procedures, profiles, statistical paradigms, some gadget, if you will. And
principles.
Well, that's correct, Your Honor, but this Court has not been clear exactly on what principles is. Principles can very well be...
Whether trauma causes fibromyalgia, isn't that an underlying principle?
Your Honor, that could be, if this Court determines that that's the case, then that's the case. The word principle has not been specifically delineated by this Court.
Well, perhaps we also have not been clear on what pure opinion testimony is. The facts in Haddon were that we were attempting to differentiate there between something an opinion which is developed by a psychologist in a clinical practice and an opinion which is developed by a fact that is not seen through symptoms and presentation in the office, but rather is seen through study of treatises and other matters. I mean, that's what we said in Haddon, correct?
Well, Your Honor, in this case, you have that. You have the objective observation of symptomology based upon the examination.
Right. You've got the symptomology that he's got the disease. The question is, though, what is the link what is the etiology of the fibromyalgia? And what I'm concerned about is it seems to me that in neither Flanagan nor in Haddon did we reach the conclusion that something that has to be only dealt with by something that is not within the clinician's practice, but rather within studies outside the clinician's practice, doesn't fit within pure opinion testimony, pure opinion, as we were trying to define it. Now,
Justice
isn't
Wells,
that correct?
There are dozens of clinical reports showing that patients report trauma preceding fibromyalgia. In fact, it's usually 25 to 50% of those rheumatologists and physiatrists that are treating this condition which report that. Our expert, Dr.
But that brings it within Fry to begin with, rather than being something that we were trying to reach and Haddon as being something that doesn't come with Fry. Wouldn't you agree with that?
Not exactly, Your Honor. In the Henson case, And again, we believe that Henson and Castillo are controlling in this case. To our facts, this court stated that the fact that a cause and effect relationship has not been conclusively established does not render the testimony inadmissible. And in fact, in Castillo, there was a scientific proposition that was rejected flatly, and this court still allowed that proposition to go to the jury. Here we have at least 3 consensus reports, 2 of which show a robust, repeated correlation between trauma and fibromyalgia. We have 3 epidemiological studies, 2 of which show, again, this robust correlation, this repeated association between fibro and fibromyalgia. And we have dozens of clinical reports showing the same. Certainly, and that really brings to my second point, and the answer to the question is if Frye does apply, if this court does believe that Frye applies to the facts of this case, then we believe that the plaintiff still prevails because the experts merely relied upon a differential diagnosis. That is the process of excluding various other conditions. They did history examination, they looked at records, they did blood work, MRIs, x-rays, all generally accepted forms of diagnosis both in the medical community and accepted by this court, and came to the conclusion that Jill had fibromyalgia. They ruled out
So
multiple
essentially
sclerosis.
what they did, I'm sorry, yeah, you were saying, they ruled out it can't be this, it can't be this, it can't be this, it can't be this. Therefore, it must be fibromyalgia, right?
That is correct, on a differential diagnosis. They also ruled out the possibilities that this condition also is caused by hereditary and genetic factors. It's caused by pathological and disease processes, which is ruled out. It can be caused by other forms of trauma, rape, war, physical assaults.
And then cross-examine and say, well, aren't there a lot of studies that don't believe that trauma can ever cause fibromyalgia?
Well,
Would that be part of the questioning of the witness?
Well, that's exactly the point, Your Honor. And we did not get the chance to have that. But the vigorous cross-examination between the experts is what should have happened at trial, and let the jury decide.
Could we go back to that just for a moment as I'm going through all the material? Tischler study, consensus documents, all of the other studies, it seems as though that we're not finding a clear consensus that trauma cannot produce this condition. It seems as though, as I'm reading most of this, that the etiology, the pathophysiology remain unclear. The syndrome of unknown origin, we can't necessarily connect it. So am I reading this correctly, or is the majority saying, no, it can never be caused by trauma?
You are correct, Chief
So
Justice.
this is the nature of the underlying data. So really what the other side is saying is that unless you have a clear consensus of causation, you can never get any kind of testimony in. Is that where we are in this case?
Well, that's not, Your Honor, because again, in Henson, it said a cause and effect relationship. It doesn't have to be conclusively established. This is a legitimate medical dispute by some of the world's finest experts that base their...
Well, that's what I'm asking. That's what it seems to be rather
Yes,
than...
exactly.
Well, you said no, it wasn't, so I'm trying to understand.
Frye is not implicated unless there is if you will, a gadget. There has to be some device, some technique, some test which can't be cross-examined. That brings the aura of credibility into the courtroom. The expert, if it's just his opinion, he's got the oath of office he has to take. He's got his qualifications as an expert. He can be cross-examined. Other experts can rebut his testimony, summary judgment, directed verdict. There's all ways to screen that expert's pure opinion testimony, or if they're just testimony at trial. However, this Frye examination is not triggered unless there's this thing from which the deduction is made to reach the conclusion that can't be cross-examined, that brings into the court this respect in and of itself.
So there's no, in your position, there has to be no general acceptance of the underlying theory in the scientific community.
That's correct. This court has stated several times that the conclusion, that is that trauma causes fibromyalgia, is not subject to the Frye analysis. It's the methodology, the assumption, the deduction that brings us to the conclusion that is subject to Frye. If this court holds that principle means the underlying scientific theory and the conclusion...
So the etymology doesn't have to be established by any statistical or epidemiological study. So how broad is this? Let's say autism. Let's get it out of fibromyalgia, autism. There's a big question, is it caused by vaccines that children get? So there's some people that think that's that. So that exposes, even though there's no general acceptance or understanding the causation, or that could be a basis of liability.